Hello, everyone. I'm Shamani Davis. Okay, just kidding, but if you looked at your program, that's who I'm supposed to be. Unfortunately, she was unable to make it today. I'm Mandy Reed. I'm the second vice president for the Women's Law Student Association. On behalf of the Women's Law Student Association Board, we'd like to thank you guys all for coming. I think you're in for a really nice treat today. And now I'm going to turn you over to the person responsible for putting it together, Lauren Holzclaw.
Good afternoon, everyone. I'm Lauren Holzclaw, and it's been my pleasure to chair this year's Edith House Lecture Committee. I'd like to join Mandy in welcoming you all here today. I'd also like to introduce you to Edith House, for whom this lecture series is named. Edith House was born and raised in Winder, Georgia. Ms. House decided that she wanted to become a lawyer when she was just 13 years old, after hearing that the General Assembly passed a bill allowing women to practice law. In 1922, Ms. House's dream to become a lawyer became a reality when she entered the University of Georgia School of Law. 3 years later, Ms. House graduated co-valedictorian of the first law class to graduate women. She accepted a job in private practice in Florida, only to become Assistant U.S. Attorney 4 years later. Over the next 34 years, she dedicated her life to the law and worked to reorganize the Southern District of Florida before retiring from the U.S. Attorney's Office in 1963. To honor her achievements and success, the Women Law Students Association created not only this lecture series, but also commissioned a portrait of Ms. House for the law school. Despite achieving what many women in her generation did not, and perhaps could not even dream of doing, Ms. House did not let the magnitude of her accomplishments affect her. In an article written at the time her portrait was unveiled at the law school, she said, "I've never figured I accomplished anything extraordinary, except I've stayed off welfare and I've stayed out of jail. Just the fact that I was a woman and practiced law at the time made a splash, but I don't see why everyone got so excited about that." Despite her modesty, the Women Law Students Association is proud to continue to honor Edith House as an example of great achievement of women in the law. Since 1983, we've invited outstanding female attorneys to speak to us about various topics in the law. The success and long life of this lecture series is sustained by generous contributions to the Edith House Lecture Fund and the continued support of the University of Georgia School of Law's faculty and staff. For this support, the Women Law Students Association is incredibly grateful. At this time, I would like to introduce Assistant Professor of Law, Sonia West. Professor West teaches courses on constitutional law, media law, and the Supreme Court. Her research focuses on First Amendment freedom of speech jurisprudence. Professor West earned her undergraduate degree in journalism and communication studies from the University of Iowa, and then worked as a reporter in Illinois, Iowa, and Washington, D.C., before entering law school. Professor West then obtained her JD from the University of Chicago Law School, where she served as executive editor of the University of Chicago Law Review and was inducted into the Order of the Coif. Following law school, Professor West served as a judicial clerk for Judge Dorothy W. Nelson of the United States Court of Appeals for the Ninth Circuit, and then for United States Supreme Court Justice John Paul Stevens. Then, before joining the distinguished faculty at the University of Georgia School of Law, Professor West worked as an associate in 2 Los Angeles law firms, where she specialized in the representation of media clients on the First Amendment and intellectual property issues at the trial and appellate levels. The Women Law Students Association sincerely appreciates her being here today. Please make welcome Professor Sonia West.
Thank you, Lauren. I am going to open some water. Okay. So I am so excited to be here today to introduce today's Edith House Lecture speaker, Dahlia Lithwick. And that got a laugh just by saying that, because my excitement at having Dahlia Lithwick come to the University of Georgia to speak with us is something I've made very well known to my colleagues, to my friends, both the real-life kind and the Facebook kind, and to my poor students, the sort of quintessential captive audience who've had to listen to me for the last several weeks count down until Dahlia actually came here. For those of you who might not know, she is most well known for her work as a senior editor and legal correspondent for Slate, where she writes the Supreme Court dispatches and jurisprudence columns. And I actually learned, and we talked at lunch today, she started doing this in 1999, which coincidentally was the same year I started reading her columns. So I can say I have been a fan from the very beginning. In addition to her work at Slate, she is a contributing editor at Newsweek and a weekly commentator on NPR, and her work has appeared in numerous places, including the New York Times, the New Republic, and the Washington Post. So what this all means is that she is one of the select few who has what I would think is got to be one of the best jobs on the planet, which is she is part of the Supreme Court press corps. But in addition to this elite, being a member of this elite group, she is, in my opinion, one of the best at covering the Supreme Court, both their opinions and the justices themselves. So I'd like to take just a couple of minutes to explain to you all why it is that I think that. So as someone who has followed the court and is interested in journalism, so has followed coverage of the court for some time now, this is the way things look to me anyway. For many decades, there was sort of a royalty among the press corps. Any place to put this? And that royalty was reigned over by the Queen, Her Majesty, Linda Greenhouse of the New York Times. And Linda Greenhouse is amazing, and she is, Pulitzer Prize-winning journalist, and she, at least from someone who reads her work, seems like she spends all her time scrutinizing every piece of paper the court hands down. I mean, every word on every piece of paper that the court hands down. And I'm not just talking about the opinions. I'm talking about the boring stuff, like the orders lists and the cert petitions that don't get granted. And then she'll connect all the dots, and she'll write amazing things saying, oh, the justices decided to hold this case over till next conference, and that probably means that this is everything that they're thinking about the case. And I can tell you, from the 1 year I got to be on the other side of things, she was completely right, and it really was amazing. And there was a number of other people who are part of this royalty as well. Many of you, I'm sure, listen to Nina Totenberg, and Lyle Denniston writes a SCOTUS blog. Then there's another reporter who I think had an interesting contribution to covering the press, and his name is Tony Morrow, and he wrote for USA Today. He now writes for the National Law Journal and the Legal Times, and he's had a long, distinguished career, but he did something that maybe some of the royalty wasn't doing, which is he came and said, yes, the court has these opinions, but they're also, it's an institution, and behind the red velvet curtain, there's a machinery going on. And he started writing about that machinery. In particular, for example, he wrote about this group of people known as law clerks, who were these newly graduated lawyers who had this influence on what the court was doing. And he started writing about them and saying, and oh, by the way, they happen to be basically all white men who came from this very select group of schools. And his work got a lot of attention, and I think has changed how the justices hire their law clerks today. So this was sort of the scene in 1999, as I see it anyway, when all of a sudden along comes this young woman with this interesting name who writes for an online magazine, whatever that is. And she came along and she added her own take on how you should cover, how the press should cover the Supreme Court. And one of the things she started doing was she started telling her readers the hidden secret that Supreme Court justices are human beings. And they are human in all the good ways, that they are quirky sometimes, and they can be surprisingly funny, they can be surprisingly kind, they can just be goofy. Justice Breyer, I'm talking about you. But they can also be human in the bad ways. They can be biased, they can be hypocritical, they can just be snarky sometimes to their colleagues and to the poor lawyers before them. And she wrote about these traits, and as she observed them during oral argument and by reading how they referred to each other in their opinions, and again, at least on my view, just was dead on in terms of what she was saying about what was going on with the justices. And she would either comment on this herself or just leave it to you, the reader, to think about what this all means in terms of the law that the court is handing down. So in addition to writing about the justices, of course, she also writes about the cases. And here she's also just uniquely fabulous, I think, in terms of being able to bring these complicated cases down to earth. And it's this side of her writing where I feel like she stops being sort of Dahlia Lithwick, award-winning, revered journalist, and just becomes Dahlia, your good friend, your smart, funny friend who's sitting next to you in government class and whispering funny remarks the whole time about material. And as long as she doesn't get you in trouble with the teacher, you end up learning so much more than you would have without her next to you. And she does all this with a great sense of humility. She'll admit in her columns sometimes that there's love, sort of getting lost in a daydream during some complicated, dense argument. But then she'll come back and just have some completely profound, insightful observation that reminds you once again to never underestimate her or her intelligence or her abilities. So that's a little bit about why I'm such a big fan and why I'm so excited. It's clear you have lots of fans here at the University of Georgia. So with that, I will get out of the way and give you all Dahlia Lithwick.
Good grief, I feel like I should sit down. I can't possibly live up to that. Well, thank you so much, Sonia. That's possibly the most generous thing anyone, including my husband, has ever said about me. And I want to thank all of you for being here. I have just been blown away by the generosity and the welcome I've received. And I especially want to thank Lauren for, my God, if this woman isn't running the space program, she should be. This is the most efficient, talented human being in terms of getting you from A to B that I've ever met. And I really want to thank you for the privilege of being invited to be the Edith House Lecturer. I don't know what Edith House and I have in common beyond the fact that I too am not on welfare or in jail, and maybe that's good enough, but I'm really humbled by this invitation. So I'm going to try to leave a bunch of time for questions because I really do have the greatest job in the world and I want to be able to answer questions, but I want to talk about, I've been covering the court, this is my 10th year. I was telling Sonia at lunch that when her first year and my first year, when she was clerking and I first started covering the court, I was still allowed to have crushes on the boy clerks. Now the boy clerks are closer to my kids' age than mine, and one of the boy clerks, one of Justice Stevens' clerks, was my camper when I was a camp counselor. So, oh, that's weird. No more crushes on them. So it's been 10 fantastic years. The court has changed in many, many ways. But I wanted to talk a little bit about how the court has changed for women. And I wanted to give you 3 little snapshots of things that happened, not in the last 10 years, in the last year, and to try to tease out what it means. So I'm going to sort of imagine the slideshow behind me. I'm going to just tell you about 3, I thought, very, very transformative moments in the last year of covering the Supreme Court. The first one was Justice David Souter retires. Barack Obama floats the word empathy as the word for the quality that he's looking for in Souter's replacement. America goes crazy. So that's 1. 2, the Supreme Court hears the kind of not all that initially exciting case of Savannah Redding. You may have read about this. This was a 13-year-old girl in Arizona strip searched by school officials for the contraband ibuprofen. She is supposed to be hiding in her bra. And the Supreme Court hears this case and behaves kind of badly, very unexpectedly badly. And surprisingly, Justice Ruth Bader Ginsburg calls them out for it. That's moment number 2. Moment number 3 probably won't surprise you. Barack Obama eventually taps a very, very well-qualified 18-year veteran of the bench, Sonia Sotomayor, and yet somehow the 3 words, say it with me now, wise Latina woman, enters the public discourse, becoming, along with don't tase me, bro, and walking the Appalachian Trail, words that no one will ever say again. And then, to boot, Justice Sotomayor, then Judge Sotomayor, spends her hearings pretty much having to prove to us and to the Judiciary Committee that she is neither wise nor Latina nor a woman, that she is in fact John Roberts in better shoes, but has no views on anything at all based on her gender or race. So that's a fairly grim, I think, 3 images of what happened to the discourse about what it is to be a woman and what it is to be a woman judge. And I thought it raises some really interesting questions for me as a journalist observing all this. I hope for you as lawyers and law students, about where women belong in the law and where women belong in the courts and how we're doing on this discourse about women and justice. And what do we do about the fact that women are special except for when they're not? And if women are special, maybe men aren't special. And what do we do with that specialness? Is it a handicap or is it an ability? It's really, really strange that we are still talking about gender and race and the law probably the way they were doing it in Edith House's time, in very, very cartoonish, caricatured ways. And so I want to sort of push past those 3 moments and see if we can find some common thread about women in judging. So let's look closely at the 3 episodes I just described. First, the rise and fall of the term judicial empathy. Also, like walking the Appalachian Trail, words that we will never hear again. I guarantee if Justice John Paul Stevens retires, Obama will not use the word empathy to describe what he's looking for in a jurist, which is too bad, because I think it's a really useful and interesting term that he tried to bring to the conversation about what we want in a judge. So when Obama talks about empathy, it's not actually a complicated notion. He's very, very clear. He used the term on the campaign trail. He used it on Audacity of Hope. What Obama means when he talks about empathy is just walking in the other guy's shoes. And he describes it as, this is the cardinal lesson that my grandma taught me, right? That before you jump to conclusions about thinking you know stuff, stop, take a breath, imagine what that other person is thinking or doing. Now, this is empathy, right? This is what I teach my children. Before you punch little Homer in the nose, think, why did Homer take your cookie? It's not a complicated notion, and yet somehow, by the time we were talking about it in the radio interviews and the op-ed pages, it had become anathema. Empathy became a code for Obama wants to put people on the courts who weep and tenderly stroke death penalty defendants, clasp them to their bosom, kiss them, love them. I don't know what empathy meant. I found myself over and over again last summer in these perplexing radio interviews where I was trying to say, I think empathy just means knowing what you don't know about other people. That's, I think, what empathy meant. But clearly, by that point, the Pandora's box was open and Obama was going to put all sorts of judicial activists who made stuff up. I think what empathy doesn't mean is worth exploring. I think what empathy doesn't mean, the way Obama's construed it and the way I think I would construe it, doesn't mean bias. It doesn't mean that one group is more important than another group. It doesn't mean that women deserve more scrutiny or more protection than men. I think even those of us who want to hear a sort of full-throated, counter-majoritarian defense of what judges do would have been disappointed by the word empathy, because I don't think empathy means you put a thumb on the scale for the little guy. I just think it means you listen to the little guy and you figure out what you don't know about his side of the story. I think the other thing that empathy doesn't mean, and in that sense it is an unfortunate word choice, was that when Obama used it, it immediately came to mean women. And that everybody started saying, this is Obama speaking in code for how he's going to tap a woman for the court. And I think in some sense it was a setup, unintentional for Sotomayor, because then I think she had to get away from the notion that she was going to tenderly stroke defendants and clasp them to her bosom. I think that in a sense, empathy was the least useful thing he could have done to her as a nominee, because it really set her up to look like she was emotional and sensitive and not rigorous. So I think it just was an unfortunate word choice that came back, I think, to haunt her. I really do believe, and I'm going to try again when Justice Stevens steps down, to say that empathy is a really useful construct. It's not a bad word. And the idea that on radio show after radio show and on television news you heard people talking about empathy as though it was tantamount to having beheaded animals in the cellar, is the worst possible quality a jurist could have, I think is just a really, really step backwards in a way from what we should be talking about when we talk about our judges. So that's the rise and fall of judicial empathy. The second thing, and this is much more concrete, is the Savannah Redding case. And this was really a spectacularly interesting moment for court watchers. Here we have a little girl, 13-year-old girl in Arizona. She's alleged to be honor student, never had a problem, alleged to be carrying ibuprofen on her person, and the school conducts a strip search in which they very embarrassingly, strip her down to her underwear and make her shake out her little bra in front of the teachers, and she's mortified, and the case comes to the Supreme Court just as a sort of, routine case about what police administrators can do. And it comes as one of a long line of cases that increasingly say, drugs, whatever the school needs to do, they can do. The court has been really, really worked in a lather for years now. Justice Ginsburg has a great a little riff in one of her opinions where she talks about tubas, drugged kids on tubas crashing into each other, like the world gone mad because of kids and drugs. Probably the only funny thing I think she's ever written, but if you're only going to write one thing, I think druggy kids on tubas is a good way to go. In any event, this case comes to the court for oral argument. It gets a little press because it is funny. There's ibuprofen, there's a bra. But, gets not much notice beyond that. Nobody thinks this is going to be a sort of watershed moment at the court. And lo and behold, the justices behave quite badly. There's a sort of a towel snapping that starts to go on, where some of the justices, to lesser and greater degrees, trying to minimize, it's not that bad, the search, which reaches, unfortunately, its low with Justice Stephen Breyer, who makes it like joke about how is this so different from when I was in underwear in gym class, and then he exacerbates it by saying people stuck stuff into my underwear all the time in gym class, at which point it's not just towel snapping, it's just inscrutable and slightly terrifying. But Justice Ginsburg, who you need to understand is very reticent about being the only woman on the court. I mean, she's been pretty quiet about it. Literally turns to him in argument and it's like, it's not like that at all. It's not like gym class at all. And you can see, it's palpable, that she thinks he doesn't get it and that searching a 13-year-old girl is quite different from being a 13-year-old boy in phys ed. And here's the part where it gets sort of interesting. Reporters all scurry off to write their pieces, and someone should write a paper on this. I think it's only 3, I haven't read every press account, are really quite shocked. Because for the first time, oh my God, there's only one woman on the court, and we're seeing it play out. And Joan Biskupic writes a very strong piece. Nina Totenberg did a very, very shocked and outraged piece, and I went home and said, they have taken not understanding what it is to be a 13-year-old girl to a new level. This is stunning. Then Ginsburg takes it one further and sits down with 2 different reporters. Again, this is not the way Justice Ginsburg generally conducts herself. Sits down with Joan Biskupic at USA Today and Emily Bazelon, my colleague at Slate, and gives lengthy interviews where she goes right out and says, the men on the court just don't share certain sensitivities. They just don't understand. And this is, in Ginsburg land, this is excoriating criticism. I mean, this is really a strong statement. What I found most interesting was the blowback. It was really interesting how it was perceived by a lot of people as her being politically correct, as her trying to silence men, as her trying to shame men, her pulling rank, her, doing the sort of injured victim routine. And she really, really took heat for what I thought was a fairly benign observation about how very strange it is to be in the Supreme Court in 2009 and hear people talking about a 13-year-old girl who's really been humiliated and traumatized. That's not in dispute in this case, as though it's kind of a nothing. So that was I thought, really fascinating. I think what Ginsburg was saying when she said they don't share certain sensibilities, sensitivities, was they don't know what they don't know. I think it was not all that different from what I think Obama talks about when he talks about empathy. Okay, so this brings us to slide 3, the Sotomayor hearings. Now this is just an irreparably broken system, the confirmation system. I will tell you right here and right now, I found out yesterday I've got the first cavity I've ever had in my life, and all I can think of is, please God, can I get it filled this summer instead of having to cover the hearings for whoever is going to replace John Paul Stevens, because confirmation hearings are so miserable. I truly would rather be in the dentist chair with a drill in my head than go through another 5 days of these. They're miserable. They're truly miserable, and we can talk about it later. This happened to be spectacularly, truly miserable because an entire career was boiled down to, and a really interesting career and a huge, massive judicial record boiled down to wise Latina woman. We could have talked about it once. I understand we wanted to talk about it twice. Not the smartest construction on Justice Sotomayor's part, but we talked about it and virtually nothing else for 5 days. Does this mean she's a racist? Does it mean she's some kind of feminist exceptionalist? What was she meaning? Now, I just want to be clear that I think while it wasn't the world's smartest word choice, if you look at the actual text of the speech that then Judge Sotomayor gave with the wise Latina woman line in it, and she gave the speech many times. It was not one time in California. It was many times. This was her stump speech. What she was saying was actually not that different from what I'm about to say, which is, look at the data. Let's look at all the studies on women in judging, and let's try to figure out, do women judge differently than men? And she really struggled with it. I mean, one of the things I love about that speech was that it wasn't a sort of a bully pulpit, like women are better. It was a very, very fraught exploration of, here's what some studies say, here's what other studies say, some judges say this, other judges say this, here's what I hope, right? And that was the key word. She said, I hope, kind of aspirational, not a descriptive sentence. She said, I hope that in a certain class of cases that have to do with gender and race, a wise Latina woman would come to a better decision. Now, we can talk during the questions about whether that's true or not true, but I don't think she was making a statement about the fact that white men were stupid or that they couldn't judge. I think she was simply saying, like Oliver Wendell Holmes would have said, the life of the law is experience, and my experience as a woman and a Latina mean that in some classes of cases involving women and race, I might come to a better decision. But at that point, it was inexplicable, and I certainly don't fault her for not trying to explain it. What she did was disavow it 11 times a day for 5 days and apologize for it and run away from it. And then she did something that I thought was even more interesting. When she was asked what she thought about Obama's empathy standard, does everybody remember what happened? Threw the president under the bus. She's like, no, 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 I don't believe in empathy. I'm not for empathy. I am balls and strikes. I'm an umpire, and whatever the president was talking about, if it isn't, fidelity to the strict text and the meaning of the Constitution, I'm against it. So it's a really interesting exercise in watching what happens when you get called over and over again, get called out for something, for being an exceptionalist, for not liking men, for not being fair. You have to retreat to this point where, in effect, you are saying, and I think she was saying, but I am a white man. That's neutral, right? That's the state of nature. That is the state of utter lack of bias, is white malehood. And that's what I am. I am so utterly devoid of bias that basically I really am John Roberts' twin, except my suit doesn't look quite so good on me. And that's, what we came away from that hearing, really with the message. And several people, including myself, have written, that sets the bar in a very awkward place for whoever comes along next. Whoever comes along next is going to have to be, the first male Asian umpire balls and strikes guy, or the first disabled umpire balls and strikes person, but it really takes the focus away from what you believe and puts it on demographics. And that was really never the point. I don't think it was Obama's point in picking Sotomayor, and it wasn't her point, but it's become the point. I look a little different from the guys, but I'm the same. I'm a white male when it comes to judging, and I think that is so pernicious. I can't tell you how impoverished the conversation about the courts are, where everybody is competing to be an empty vessel who has no prior thoughts or experiences or opinions. So, what does the data show? And I get to say, wise Latina woman, because I'm never up for confirmation. And I can tell you that what the data shows, believe it or not, is that women judge differently. And we can do with that what we want. We can say we can explain it away, or we can not explain it away, or we can do what Sotomayor said, which is, here's why I think we judge differently. But the data is really interesting, and thankfully a lot of studies have been done about this. But before I tell you what the data shows, I just want to be perfectly clear that the most interesting thing for me from my first 7 years covering the court was that no two people were more different than Sandra Day O'Connor and Ruth Bader Ginsburg. So it is a terrible mistake to say women judges do X. They don't. And they don't approach cases the same, and they don't think the same, and they don't write the same, and it was a really useful enterprise. It's actually why I think it was very, very bad to go back down to only one woman on the court. Because as long as you had two, you could see gender actually makes very little difference at all. Gender only means that there's two incredibly different women on the court. That said, here's what the data shows. And like I say, I don't know what to do with this, so that's why I'm here, so you can tell me. The data is first of all, quite equivocal. There's no great meta study yet that tells us anything definitively, but it does, there's some studies from 1993 and 86 when they first started looking at this stuff. There was a study of state Supreme Court judges that showed generally female judges more likely to decide for plaintiff in sex harassment cases. So that's one chunk of data. There was actually some really interesting studies that were done. There was one done in 2000 by Jennifer Siegel that showed the opposite. She studied Clinton appointees and found, lo and behold, in all the district courts, they were actually much less likely than their male counterparts to find sex discrimination in sex discrimination cases. And the part of it that I find very interesting, which is the secondary effects. What is it like? How do women on a panel affect men on the panel? Those studies also were very, very equivocal for a long time. So I think the really good studies start coming about 5-6 years ago. There's one study that is, I think, pretty compelling by Jennifer Parisi, Yale Law Journal, 2005, where she actually does some really rigorous work. She looks at all the harassment and sex discrimination cases decided in the federal appeals courts from 1999 to 2001. So really, if this is my definition of empathy, right, knowing what you don't know, it turns out empathy is contagious, and that men can catch it, and that maybe it's a good thing. And I'm not saying this to be sort of snarky. I'm saying it to say that I think the real, to me, power of these studies is not that women make better decisions. It's that women are able to sit on a panel with two men and say, wait, I know what this is like. You don't get it. The same way Justice Ginsburg did in the Redding case. And I don't think that means that men don't know things. I think it means, very simply, that women know different things. So if I were to try to connect the dots between all three of my slides, I would say that's the connection. The point of connection is knowing what you don't know. Now, this is so utterly obvious if you look at the Supreme Court, where Sandra Day O'Connor, for instance, in her book, The Majesty of the Law, says, heck yeah, I didn't know anything about the Jim Crow South until Thurgood Marshall started talking. Everything I know about race, I learned from him. And she goes on to say, you know why? Great storyteller. He could just capture you and tell you something that you didn't know that made you realize how wrong you were. And Scalia, it was equally open. Believe it or not, Antonin Scalia has said, oh my God, of course we spoke differently and ruled differently when Thurgood Marshall was in the room. How could you not? One of the interesting things, and maybe we can have a little talk about it if I can stop talking, but one of the interesting things is trying to, if you accept that men will conform their judicial decisions to the opinions of women on the bench, one of the interesting questions is why? Is it a bad thing or a good thing? And there's a bunch of really interesting theories for why. Some of them are very, very dark and scary, and some of them sort of seem to make sense. I'll just lay them out for you. One is that women on a panel, a woman on a panel with two judges on the Court of Appeal is just very persuasive. It's just able to say, wait, I had a massive pay disparity between me and the guys at my firm, and here's what it was like, and here's how it happened, and here, a la Lily Ledbetter, is why I didn't know. So that they're just persuasive because they're able to tell exactly as Thurgood Marshall did, a story that men haven't heard. Another version of why this happens is that male judges on a panel with female judges are inclined to defer. In other words, they start to hear that story and they say, you know what, I don't know anything about disparities in pay, so I'm going to just assume you're right and vote for this woman. I don't think that's a bad thing, but maybe it's more marginal than how persuasive the female judges are. Then there's a theory that there's just what the theorists called is log rolling or bargaining, where male judges on a panel with women judges will say, oh, you know what, I'm going to just give this one to you. I'm going to give it to you because clearly gender cases matter to you. Don't matter so much to me. And when we get around to the environmental cases that I care about, you're going to defer to me. So this is a sort of a larger bargaining strategy. Again, we can talk about the merits. And then there's a theory that when women start talking, and this goes back to Ruth Bader Ginsburg saying the guys on the court just don't get it, men feel silenced. They just feel like they can't say, I don't really think he did sexually harass her. It's too hard in this climate, and that men tend to shut down in those conversations. And so it's not quite deferring because she's a persuasive storyteller, it's deferring because men feel like they just can't speak. All right, so if I'm right that what women bring to the bench is not just the sort of totality of their different experiences, their ability to persuade, but the fact that they know something that men don't know, and that they have the ability to say, not that I'm better, but that I'm different, I know things you don't know. The question really then becomes, what are the implications? What are the implications? Do we need more women on the bench? Well, to me, the immediate answer is yes, right? I mean, if it's clear that as soon as you put a woman on a 3-judge panel, the instance of finding for the female plaintiff goes up, then if we put more women judges on more 3-judge panels, maybe we'll find more cases of sexual harassment and discrimination. There's another piece that's really interesting, and that is, if you look at the history of where women made huge breakthroughs at the court. There's an amazing book that came out last year by a scholar, a historian from Yale, called Fred Streibe. And he goes through all of the big progress in the 60s, 70s, and 80s in women's rights movement. What's astounding is that in every big case, it happens because some justice has a female law clerk, or has a male law clerk who's married to a woman lawyer, or there's this amazing network of, at that point, young women professors coming up through academia who are starting to pull strings behind the scenes. It's really stunning. There isn't a moment in which, and some of these men, by the way, are the lions of the liberal movement. Bill Brennan, Thurgood Marshall, who just are right to the bitter end, insisting, women don't need equal treatment, women don't need to clerk at the Supreme Court, women make me feel kind of weird. Right up until the bitter end. Ruth Bader Ginsburg couldn't get a clerkship literally because there were justices saying, I roll up my sleeves, and, when I take my jacket off and I roll up my sleeves, as though what? Ruth Bader Ginsburg would attack them with sexual desire that was just utterly unleashed by the sight of his hairy forearms. This is what these women were being told at every turn. And so the only point I really want to impress on you is that this wasn't a situation in which women made these huge legal breakthroughs because men gave them to them. It was women plotting and conspiring and harassing. And, this is the same story you now hear about gay rights. That justices who think they know what they think suddenly have a gay clerk. And suddenly everything changes for them because they figure out, I know what I don't know. And so for me, the implication of this whole trend is that I think there's this whole world of sub-law that we don't know about, where it's not just what happens in the case books. It's not just what happens when you read the final opinion in these cases. It's all of the machinations and the manipulations and the pulling of strings that happens behind the scenes. And those people were women telling their stories in much the way Thurgood Marshall was telling his stories. And so I think the other implication I really want to share with you is tell your stories. is that be sure that, we were talking at lunch about just the ridiculousness of being pregnant and trying to have a high-power career. And so what I would do is take my huge pregnant self into the Supreme Court and cover cases and hope my water didn't break, and take my huge pregnant self back to my computer where I couldn't fit because I was eating a bag of Oreos a day in the last few weeks of my pregnancy, and I would pretend I wasn't pregnant. And I would pretend that my life was no different from the men around me. And it took a long, long time. It takes a long time to say, you know what, we are different. We do have different experiences. Probably the defining memory, men may want to block your ears, the defining memory that I will always have of the John Roberts confirmation hearing was running around the Dirksen Senate building with like a 40-pound breast pump machine, because I had to plug that in. I had 2 hour, 2-3 hour sittings and then 15-minute breaks, and there were no bathrooms where you could plug that pump in. And so I was like a crazy person running around trying to find a plug. And, it was embarrassing until I realized if somebody knew that there was no plug in the Senate where you could pump, where probably other people would want to pump, maybe this wouldn't happen to the next person. And so you have to learn that even though it makes you feel so intensely weird, I just said breast pump, that if you don't do it, if you don't continue to do it, those stories don't get told, and people don't know what they don't know. Doesn't mean men are clueless. Doesn't mean Joe Biden needs to pump, have a breast pump in order to have had my experience. It just means that if you hadn't gone through that, I know it's a trivial example, but if you hadn't gone through it and shared it, we're not moving forward. The conversation is not moving forward. So the final implication to me, this will come as no surprise to you, if I'm right that part of being a good judge, even a great judge, is acknowledging that you don't know what you don't know, it seems to me we have to put to rest the idea of judges as neutral umpires. The idea that the best judges are sort of, open vessels who are told by the oracle what the law is, and that the less they know, the better. And that the fewer experiences they have, or biases or prejudices, the better and more fair they are. And what really scares me about the state of the discourse today about judging is that really seems to be the ideal. The ideal is to be some kind of utterly neutral microchip who's never had an experience that changed them profoundly or informed the way they feel or made them angry. And it seems to me that if that's the ideal we're holding ourselves to, women are never going to have a reasonable confirmation hearing. They are always going to have to sit there and say, I'm not biased, and here's why. It can't be the presumption that unless you are, a white male who went to Harvard, you're just crippled with prejudice. And so I think we really, really have to unspool that narrative. I understand why it's attractive. Trust me, not a day goes by where somebody doesn't say, oh, you want judges who are just making it up? As though that's the alternative, the sort of mime version of the Warren Court where there's actually no rules. There's just people who, wear a lot of hemp and make stuff up. And that's, talk about cartoonish. That can't possibly be the only alternative to balls and strikes. And so I think, particularly now I'm speaking to the women in the room, but you know what? I'm not. I'm speaking to the men in the room too. I think every time you hear the words balls and strikes and neutral umpire, ask yourselves, who's been setting the strike zone for 200 years? Not women. And that really, really, are we going to say that strike zone is the one we accept? I think that's a dangerous way to live our lives. So, I'm going to give you some good news. Here's something that you don't know, and that is, when I was covering the Sotomayor hearings, and I confess, it was very frustrating to watch this woman with whether you agree with her politics or not, I don't think it's in dispute that she was very well qualified. She had 18 years of really amazingly No gun cases, no abortion cases. I mean, she had as uncontroversial record as you could, if you were growing an uncontroversial record hydroponically under glass. You know, Sonia Sotomayor had it. You're never going to see that again. And yet, we were fighting about wise Latina woman, and then when it went even south from that, and she was being accused of being a bully judge. Do you remember? Does everyone remember the cringeworthy, you know, are you a bully? So I really, I have to say, by about day 2 or day 3, I felt like it's not fun to be a woman and watch this Judiciary Committee, which has only 2 women on it, beating her up for saying, I think, in a convoluted way, that maybe sometimes women get it right. And then I would turn around and I would look at the back of the chamber, and this is what you don't see when C-SPAN is covering the hearings. You don't see the audience. Now, the audience was comprised of 2% crazy people who are going to scream things and get dragged out, and we in the press corps were all betting. You take a look at them and be like, who's getting dragged out today? You could see their, like, the Cookie Monster googly eyes start to go. You're like, that guy's gonna blow, and then he's gone. So that was like a small fraction of who was there. And then there was just these amazing women, these young high school women, who would stand in line for hours to be in that room for a little bit of time. And they would just sit there row after row after row. They didn't really know the law. They couldn't really talk about the Commerce Clause. Didn't much care about ERISA. But this was, for them, this transcendent moment where a Latina woman was getting confirmed to the Supreme Court. And you would think, I mean, if I was depressed, you'd think they would be devastated. You'd think, turning and looking at them and seeing what this woman was being, how she was being treated, that they would just be angry and horrified. You know what? They were beaming. They didn't care. They knew this didn't mean anything. They knew she was going to get confirmed. And these girls literally were soaring. I mean, you could just see the absolute achievement. What they saw being modeled for them, they had never seen before. And it reminded me, for one thing, I think the America in which we really care deeply about the statement, wise Latina women, is ending. I don't think when my grandson, please, is confirmed to the Supreme Court, we're going to be talking about, he's never going to get on the Supreme Court. I can see Sonia's face. She's like, not your grandkid. Not going to happen. Not after you wrote that. But I really think we're not going to be talking about this for much longer. But really, more poignantly, these girls know what they know. They know what they know. And I think it's really, really important for us to kind of hold on to that this is a very, very impoverished dialogue about race and gender in the bench, but most of us aren't having it. Most of us are working and we're living, and we know that we don't hate men, and we know that judges aren't just umpires. So this is this just tiny little piece of theater, and it's like a jack in the box. It pops up, you know, every couple of years we have to deal with a confirmation hearing that really reduces everything that is interesting and important about the law to just ridiculous Yosemite Sam, you know, silliness, and then it's over. And that's not what the law is. It's not what judges are. It's not what we are. It's not what lawyers are. So please, please, I think as disheartening as some of these remarks have been, I think that we're headed in a good direction. And I think that as tremendous as it is to have 2 women on the Supreme Court, imagine when there are 3. So on that note, I thank you for your time, and I am delighted to take questions. Anyone? Yeah?
I'm not so sure, maybe I live in a little academic bubble. I'm not so sure the wise Latino woman thing is as important to all of America as it looks like in the confirmation hearing, but America's being told by what used to be broadcast journalism that matters. If that's the case, are you so sure it's going to get better rather than worse?
I think the nut of what you're saying is absolutely true, which is that the themes of any one confirmation hearing are set months before the hearing, and they're set by the media. And that if the media hadn't jumped on that, just as if they had not jumped on her ratings, her ratings by lawyers, that wouldn't have been the story we were telling. And so I think you're quite right that the media is complicit. To my mind, the really troubling part of that is why is it that the Senate goes there? In other words, if we can all agree that's not the story, why is it that every senator asks that question? It's certainly every senator from the GOP in this case asked that question over and over. And remember, this is a bipartisan problem. I mean, this was, when it was Sam Alito up there, it was, why were you a member of that racist group at Princeton? That's worthy of half a question. I would give it 2 minutes in what it telegraphs about Sam Alito. I just don't think it's that important. Is it worth it to have every senator on the Dem side ask the question about Cap twice? So I really think, I mean, I will take responsibility for the fact that I think the media does a horrible job about explaining what these hearings are. Now, part of the reason we do a horrible job is because the hearings are useless. And that really, truly, I think if the senators understood this is a teachable moment for America. This is a way to teach America. And I'm not saying teach them about ERISA. I'm saying teach America about what judges do and why we care and why this is on television obsessively for 5 days. And to me, when they denigrate the process by just doing the talking points that they heard, be it on Fox or MSNBC, I don't care. I think that's, at that point, we've created a circle. The journalists have started it and they're perpetuating it. And let me just be clear, I think the journalists started because we don't know in advance of a confirmation hearing how to talk about a confirmation hearing either. We're as dumb as anybody else. I mean, we have no facility with the language of this is what advise and consent means, this is the Senate's role, this is what, the progressive view of jurisprudence, we're awful. And so we reduce it to these awful, horrible gotcha moments, the sort of root through the dumpster moments that I think are, and the only other thing I would add, just, to again put a gloss on that point, is that these images last forever. I mean, this is the last time you saw Sam Alito, well, other than the State of the Union. That's not true. But up until then, the last time you saw Sam Alito was when his wife went running out of the chamber in tears. Is that really the image we want to have of our justices for the next 20 and 30 years? And one of the things that makes me crazy is because there are no cameras in the court and because the justices are so reclusive, these images from the confirmations are frozen in amber. And people have ideas based on things, a soundbite that happened in a confirmation hearings. That's the whole story. That's all they know. And, it's just, I think the whole process denigrates the Senate, denigrates the justices, and denigrates the rest of us. I'm as much a First Amendment guy well, not as much as you, but I'm a pretty big First Amendment guy. If they pulled the plug on that process and did it on paper, I'd be the happiest girl in the world. Anyone else?
I really enjoy what you say about the importance of telling stories, standing up for what you believe in and sharing those. But I'm curious that the confirmation hearing, it seemed, as you explained, Sotomayor chose the path to walk back from her narrative that she had created throughout the record. And in the end, she was confirmed, so we got what we wanted, but what do you think the cost was there politically for our country? Where you have on one side all these white men yelling at her that she's a bully and a racist, and she walked those statements back instead of taking a strong stand and perhaps turning the table.
Well, there's two answers. One is we learned this at the Bork hearing, that you don't say a word. The rule of confirmation hearings is, Arl Inspector gets up every single time there's a confirmation hearing, and he talks with that marbly way. He goes, there's no point in doing this because everybody just says as little as they have to say to be confirmed. And it's true. If you offer a scintilla of actual personality or actual doctrine or evidence that you have thought about the law, that you discussed a case in law school, well, you're Bork. So there's a huge incentive, I think, for the candidate, for the nominee. And in fact, whenever I give versions of the speech, someone always gets up and says, you're being way too hard on Sotomayor. Her job was to get confirmed. And anything over and above that would have been crazy. Now, there's a second piece of it that in this particular case is really interesting for gender and race reasons, and that is, if you believe, as I believe, that the whole point of the run-up on the Latina and the wise Latina and the bully thing was to get her to lose her temper, and I think that was the point. I mean, do you remember Lindsey Graham being like, as long as you don't just completely go bananas, you're going to be confirmed. So why would she then, stand up and make a strong feminist statement about what she'd done or what she believed? She had every incentive to just be a plant. I mean, I mean like a plant, a ficus, to just sit there and be a ficus. And that's what she was. And, I think that there's a strain of that that's really bad for women, because what it means is, if Sotomayor is the person that we know her to be from the Second Circuit, which is smart and fiery and, a big talker and engaged and brilliant, then she rolled all that back until she was, really a doormat. And what kind of message does that send? So I understand what you're saying, but her job was to get confirmed. And I think that had she done anything that evinced that she had a temper, or that she had strong and passionate beliefs, or that her own story had in any way influenced her jurisprudence, that vote wouldn't have gone the way it did. So, I mean, it's part of why I think these hearings are so dangerous, because they give you the illusion that you're getting to know someone, and what you're getting to know is the absence of someone, is someone taking themselves out. And it's just so utterly, utterly useless. And I think in this particular case, not particularly good for women. Anyone else?
In talking about what you called just now, her sort of rolling herself up into a doormat, or having to kind of reduce what is happening into calling balls or strikes, what role do you think that sort of a process of legal socialization or legal equalization is having in that? I guess in saying that, it's sort of, I believe, the process that we're in right now, the process of law school and taking those first jobs, whatever it is you're doing, it sort of shapes us into that to some extent. Do you think that is playing a role in sort of the demonization of women in the law to some extent?
I'm almost more interested in what you guys think of that than what I think of that, because I haven't had that experience. I've been allowed in my career to have a very strong voice and to write about breast pumps. So I sort of feel like I'm in that tiny sort of tiny bubble of people who maybe didn't feel. I mean, I also want to cop to the fact that I was the woman who had no trouble talking in college and stopped talking in law school. I mean, I was one of the vast percentage of women who feel they can't talk in law school. I mean, I had that experience, and I clerked with a bunch of guys who, routinely asked me to crazy bake cookies and make the coffee, and so there's that. But I think that one of the reasons, I'm actually kind of going to loop around to, I think, when Sonia was mentioning really epic Supreme Court reporters, it's kind of not an accident that many of them are women. This is a fantastic beat for women. And there's no analog, I think, in politics where, I would say, 4 of the top 7 or 8 Supreme Court reporters are women. So this happens to be a beat that's a great fit for me as a woman, but I know what you're saying. I mean, I think that it's definitely true that, and I often, when I'm asked to speak to groups of women about work-life balance issues and, how my firm is treating me, and I always say, you just kind of brazen in there and say, look, I need this time with my kids, or look, I need flex time, or look, I don't want to be on the mommy track. And they always laugh at me. I mean, they're like, yeah, you may as well just sort of be like, oh, see, Pluto? I want Pluto, I want a planet. So I think, it's not something I have great insight on because it's not something that's really defined me, but I also think I am one of 3 people with a JD, who hasn't had that experience. So maybe I don't know if other people.
I guess maybe more pointed, do you think that that is playing a role in judicial decision-making, or in appointing judges? Because having done some empirical research on the effects of women on the judiciary, and seeing,
it's interesting because the study that I cited to you with the Clinton appointees, right? So it's probably not an accident that in some kinds of judges, and I think this is going to change very quickly. I mean, I think the kinds of people that were women who were appointed in the Clinton administration are quite different from the kinds of women who are being appointed now. So I think already some of those studies are being dated. I always thought one of the most intriguing things, you remember I said the difference between O'Connor and Ginsburg? There's only a couple years age difference. They are two such totally different generations of feminists. It is stunning. And O'Connor, often in these cases where you think she would have unbelievable amounts of compassion for women, has this kind of pick yourself up by the bootstraps, why are you belly aching? You know, I mean, really a fairly tough love view of what women are entitled to. Ginsburg, very different, you know, very much the next wave of feminists, very much, you know, has a sense that, you know, women need more solicitude. And so I think that that's generational a little bit. I also think, you know, and I didn't make this point, but one of the things that's interesting about these studies is the cases where, like in abortion cases, where there's actually not a difference. So it's not, you know, like these studies tend to focus on sexual harassment, you know, discrimination. It's very interesting that in some areas where you'd think it would make a huge difference to have a woman on the panel, it has no effect at all. And I haven't yet seen a study explaining that. I think that's really interesting. But I think I just want to be really clear that I think there's a huge difference between what women judges, how women judges used to think about women, and how women judges think about women now. And I think that's a little bit a result of just having a whole lot more women judges on the bench. Yeah.
I guess my question that I was thinking about is, it seems like the two major problems you're identifying across all three. The first is what he was talking about, which is basically a lack of nuance in the news media, which creates these like soundbite moments you described. And the second being the institutional failure of like, you know, senators who don't even necessarily know much about the law, talking to a public who doesn't have any understanding. It's a lack of nuance across both. So I guess I'll ask you the hard question of how would you change that, both from the media side? I know it's hard, but you can't, you know, you can't write smart things to dumb people, right? and then on
Well, if that were the quick case, I would have no job at all.
and then on you have smart readers. And then on the...
My dad says thank you.
and then on the political side, which is probably an easier question to answer, which is how should this be structured? How should it be, you know, law professors questioning them or other justices? How can we get a reasonable process? Should we just scrap it all together?
Well, I'll start with the second. I mean, I think, I really think the process might be unfixable. I think it's unfixable because the problem is now the logjam is at both ends, right? The questioners don't know how to question, but the answerers won't answer. So even if you have you know, Erwin Chemerinsky up there with his like power tool, you know, it's not gonna, I don't think it's gonna make a huge difference because there's 72 different ways to evade, right? What you're asking me is too specific, what you're asking me is too, you know, too vague, it's too narrow, it's too broad, it's too, you know, it might come before me, it has come before me, it came before my brother, you know, like there's just too many ways to not answer, so it's pointless, it doesn't matter how good the questioning is. And I'm a big fan of Ben Wittes's book on this. I'm a huge fan of Chris Eisgruber's book on this. I think most of the real scholarship says this is not fixable. Do it on paper. They used to do it in a half a day. Look at the paper. I think that the spectacle helps nothing. It helps America feel like they were part of choosing a Supreme Court justice. You know, as to the other is much harder for me, you know, as a legal journalist. I don't think we do a great job of writing about the law in this country. I think we're ridiculously results-focused. I think that we can't write a column without saying whether a judge is a Republican or Democrat appointee, and I think that the minute you've done that, you're not writing about the law. I think that we do a pretty bad job of explaining cases, by and large. I think we don't do it, and I lump myself in here, I mean, for all the kind words, you know, we really don't have a very, very good way of explaining the law, and I think one of the ways is that legal reporting has gotten very politicized. Even in the past year or two, I've noticed a real difference, you know, where everything is so focused on, you know, not what the Constitution says, but what we think it should say. And I think that cable news is not helping that. But I really think, for one thing, and this is going to make me sound like a colossal snot, most of the Supreme Court reporters in the press corps don't have a JD. By enormous margins, they don't have a JD. I don't know that you can really, some of them, look, if you do it, the nice thing is they all stay there for 30 years. So, you can figure this out. But, the nature of the media is, it's sinking like a stone, and for some good reasons. It's really, we're not doing a great job on a lot of things, and I think we're doing a terrifically bad job on the law. So, how would I fix it? I would stop focusing on results. I would not be so obsessed with case by case that I can't talk about trends, which we don't do. I think we're very deferential to the courts still. And alternatively, I think we attack the courts when it's not warranted. So we have a lot of problems, but I think, you nailed it when you said nuance. And the more you sort of strip it down and politicize it, the less nuance there's going to be. I guess, last question.
When you speak about that infectious empathy that you were talking about, about people kind of presenting their ideas to someone else that's not capable of understanding something from a perspective that's not their own, I understand that that's a really great way to lead to better representation of a lot of different groups that are usually not represented adequately in America, like different racial groups, socioeconomic groups, gender groups, things like that. But is there an effective way to get that in American jurisprudence? Because it seems as though it would be impossible to meet every situation there.
Well, and I don't know that, it's interesting because now we've engaged in, we've started the Stevens is retiring, who do we want on the court? And, already it starts like there's never been an Asian American justice. So there's an enormous lobby for that. There's an enormous lobby for the first blind justice. Everybody wants to see someone on the court who looks like them. And that's not illegitimate. The court becomes legitimate to you when you see yourself in it. So it's not... But, there's only 9 seats there, and so we're not going to get, everyone represented. I think that what's going horribly wrong with the court isn't so much about skin color and demographics. I think it's about experience. To me, you've got the narrowest group of life experiences you've ever seen on the Supreme Court. There's not one person who's held elected office. Everybody's come up through one of 4 Ivy League schools. They've all, to the extent that they've worked in government, worked in the executive. It's really just an unspeakably narrow bandwidth that's represented. And that doesn't mean that Scalia and Thomas are the same guy, but what it means is that we don't have people on the court who were elected a la Sandra Day O'Connor. We don't have a governor a la Warren. We don't have anything that looks like life experience other than having been a judge. And, one of the things that's really problematic for me is that when people say, well, maybe we could get Jennifer Granholm on the court, maybe we could get Janet Napolitano on the court. How are those people ever going to get confirmed? We've created a situation where if you don't have an 18-year judicial record, you don't have a chance. So much more important to me personally than having a court that perfectly reflects, American demographics. And I'll bracket that by saying this one still really isn't even close. I love the Canadian Supreme Court. I love all those women and the chief and her big furry robe, and it's really like you have a sense that they're getting closer to something that looks like, proportional. But I don't think proportion is critical. I think what's critical is having different stories, different life experiences. And sometimes I imagine what conferences are like when everybody's like, oh, when I was at Harvard, oh, when I was at Harvard. At some point that's not, discourse. So I don't want to diminish what you're asking. I think it's important. And I think, to his credit, Obama's doing what Clinton did, which is put, what he's really focused on is putting minorities on the court and putting women on the court. That's what he's doing. But I think that's half the story, and I think the other half of the story is starting to pull people back onto the courts that come from other walks of life. You have all been insanely patient. Thank you so, so much, and for this very generous welcome, and thank you.